Okay, so today I thought I would talk to you about whistleblowing. I don't want to spend a long time talking about the law. It's quite a law-heavy subject. So I thought what we would do is look at some real-life examples of cases that have been brought for whistleblowing, so I can highlight some of the traps that employers can fall into and how hopefully to avoid them. Now, I said I didn't want to talk about the law, but here it is. The reason I've put that slide up is that if you are faced with a whistleblowing case, it won't say whistleblowing on it. The whistleblowing is just a colloquialism really. It's actually a disclosure under the Public Interest Disclosure Act. So you'll see PIDA all over the claim form, not whistleblowing, but this is what it is. So what is whistleblowing? Well, in short form, it's a worker complaining that their employer has done something that fits into one of these 6 categories. They have to make a qualifying disclosure, and I'll come on to some examples of that in a moment. But the leading authority gives us a definition of qualifying disclosure in that it's got to be the passing of information. And the example that was in that case was if somebody said, the wards have not been cleaned for a month and yesterday's sharps were left lying around, that's information, that's a qualifying disclosure. As opposed to that, there is a general accusation of you're not complying with health and safety legislation. That's an accusation, it's not passing information, so it's not a qualifying disclosure. When you look at the 6 categories of wrongdoing, they overlap quite significantly. Now this gives your whistleblower a pretty wide target to hit. So it's important to just be mindful of it. Who can blow the whistle? Well, the short answer to that question is any worker. Now, people who've been to the seminars before will have heard me talk about worker status and the differences between an employee and a worker. Under the whistleblowing regs, the definition of worker is very, very wide. It's deliberately so. So the rule of thumb is anybody who comes to you and complains about wrongdoing, treat it seriously, and if you have to, we'll get into the whys and wherefores of whether they can actually blow the whistle at a later date. The more important question for me is what protections are afforded to the whistleblower. There's 2 protections that are afforded to them. The first is there's a protection from dismissal for blowing the whistle. That's pretty straightforward. And the second is a protection from detrimental treatment for blowing the whistle. I'll come on to some cases of what detrimental treatment may be in a moment. But one of the things to remember for whistleblowing cases is A, there's no financial cap on the awards that can be given, and they are pretty significant. And secondly, there's no qualifying period of employment needed to protect the worker. So they're protected from day one. As you can imagine, with no cap on the finances and no requirement for a qualifying period of employment, people will blow the whistle about anything, try and avoid the cap and get around the 2-year service requirement. Some of the cases that have been brought, pretty tenuous. Right, enough with the law. Let's have a look at some cases. A versus X. In this case, Mr. A was a branch manager for a major employer. 2 of his staff came to him and told him that they'd been subjected to indecent assaults and sexual harassment by a senior manager, and we're going to call him Mr. Z. Mr. A did the right and proper thing, relayed the complaints to the managing director. Managing director started the investigation and suspended Mr. Z. So far, so good. Another director then got involved, and he told Mr. A and the 2 victims that if they told anyone anything about what was happening, they would be dismissed and sued for slander. Not so good. Mr. A was then asked by another member of staff if Mr. Z was ever coming back. And Mr. A is reported to have said, well, he might not be coming back. Mr. A was then disciplined for that comment, and he went off sick with stress. He later resigned, citing detrimental treatment for blowing the whistle. The tribunal was not impressed. They found that instead of praising Mr. A for doing the right thing, they'd subjected him to a detriment, and they awarded him £140,000. Unfortunately for Mr. Z, it didn't stop there, because the employment judge passed the decision back to the Crown Prosecution Service, who decided that Mr. Z needed prosecuting, and he was later jailed for what the judge in his case described as outrageous sex assaults. In Badger versus the British Transport Police, in this case, the claimant was a very senior barrister. British Transport Police wanted her to be their head of legal. For some strange reason that's not really clear, they had to engage her through an agency to start with. But they said to it, don't worry, you're a shoe-in, and to make sure you're comfortable, we're going to give you a 25% pay rise, which they did. They had to advertise the post externally to comply with their collective agreements with the unions, but they still assured her, said, absolutely, don't worry, job's yours. About 5 days before she was due to have her interview, she found her line manager destroying prosecution files in the most imaginative way possible. He was throwing them in the bin. She reported that. She blew the whistle on her line manager. So far, again, so good. She went to her interview 5 days later to find that she was being interviewed by her line manager's best friend. And sure as night follows day, she didn't get the job. She didn't resign. She brought a claim on the grounds of detrimental treatment for blowing the whistle. The tribunal awarded her £218,000. Now, Mr. Bathier, he applied for and he got a job working with a merger and acquisition company in London. This company was involved in financial transactions all over the world, and part of his job was to make sure that they were compliant with various different financial conduct authorities around the world. One day, his chief executive came to him and wanted to do a deal that would have put the company in breach with finance stock exchange rules in Australia. So, Mr. Bathier did what his job was to do, said to his boss, can't do that, you'll be in breach of the law. He was rewarded for doing his job by his CEO throwing his digital diary at his head. I didn't know what one of those was. I had to have a quick Google. Sorry. Mr. Bathier decided he wasn't going to resign either, but he was going to bring a claim for detrimental treatment, and he was awarded £805,000. Simon, if you've got a digital diary, feel free. Brown versus the Welsh Refugee Council. This was an interesting case because the tribunal found that just because the worker is wrong about what they're disclosing, it doesn't mean that it's not a qualifying disclosure. In this case, Mrs. Brown joined the council, and shortly thereafter she became concerned that some of the expenses being claimed were fictitious. She raised her concerns, and one of the directors was suspended. An investigation was carried out, and that director was put back in post. The results of the investigation were that, yes, to the casual observer, those expenses did look dodgy, but actually there was nothing wrong with it. He was claiming those expenses legitimate. So that's fair enough. Unfortunately, when the director came back to work, he took the view that the interview panel that had interviewed Mrs. Brown hadn't been put together properly, so he sacked her. She complained to the tribunal, and they found in her favour, but they won't disclose how much they gave her. In Frost versus Boys & Co., this was another interesting case because the qualifying disclosure was all about rumour, and it wasn't something that actually happened. Mrs. Frost was a store supervisor and she'd been there for 10 years. And she became suspicious that her colleague, Mrs. T, was shoplifting, and she reported that concern to the manager. The manager, we're going to call him Hannibal, did nothing about her concerns, but he was later heard talking about an insurance fraud. Mrs. Frost reported the conversation about the insurance fraud, and for good measure, she threw in a bit of gossip that Hannibal, Mrs. T, were having an affair, and that Mrs. T had had an abortion. She was dismissed for making up malicious rumours, but the tribunal found that she'd made those disclosures in good faith, and she believed them to be true. They said that the additional matters were rumours, so they weren't invented. So it wasn't malicious to put those in whistleblowing claim or to repeat them. In judgment, they found that Mrs. Frost was a very serious-minded and intense woman, and they upheld her claim. And again, they won't tell us how much they gave. So, why is this relevant to you? Well, the first reason it's relevant is it's an ever-changing area of law, but the pitfalls and the consequences for getting a whistleblowing claim wrong are massive. Often employers come to us and they'll tell us about a minor grumble, and they think, oh, it's just a bit of moaning, it's just what happens. But actually, if you ignore that grumble, consequences can be so severe. The risks of ignoring it are very, very high, so even if it seems like a grumble, you should take it seriously. The PEP clients in the room, if you get a grumble, just give us a call, we'll go through. What you need to do is make sure that your managers are alive to the risks of whistleblowing, so that if it happens, you can stamp on it quickly, deal things properly, protect yourself.